Student visa refusals happen for specific reasons. So do cancellations, genuine student concerns, and course progression issues. Most education agents can handle straightforward applications. When complications arise, they refer you elsewhere, or they guess. We handle the complicated cases directly. Here's why that matters. Most education agents operate within a narrow scope. They help you apply to universities, secure offer letters, lodge visa applications, process COAs. That's their service model. This works for straightforward cases. Recent high school graduates, clear academic progression, no visa history complications. But according to the Department of Home Affairs data, student visa refusal rates have been climbing. Recently, the refusal rate for student visas hit 17%, up from 13% the year before. For certain nationalities and course levels, that rate goes even higher. Here's what triggers those refusals: genuine student concerns. Immigration questions whether your course choice aligns with your background and career plans. Course progression issues. You're switching fields, pursuing a lower-level qualification, or your study path shows inconsistencies. Financial capacity doubts. Your funding sources aren't adequately documented or don't match your status circumstances. Weak ties to home country. Immigration sees migration risk because you haven't demonstrated reasons to return. When these complications surface, standard education agents hit their expertise limit. They don't have migration law training. They can't analyze refusal letters from a legal perspective. They can't build tribunal appeal cases, so they refer you out. Your case gets handed to someone who doesn't know your full history. Education One Australia operates as both an education agency and migration practice. We map study pathways and handle visa applications. We also manage refusals, cancellations, and compliance issues, and administrative review tribunal appeals. Our team, led by in-house registered migration agent Indah Melindasari, means when your case becomes complex, you don't get referred elsewhere. Your case stays with specialists who understand both the education pathway and the migration law requirements. Over the past 15 years, we have worked with more than 2,000 students, many of whom came to us after refusals or with complicated visa histories that other agents wouldn't touch. Let me show you the difference in methodology through a real case. A 26-year-old woman came to us after her first student visa refusal. She'd worked with another agent who told her to pick a different course and reapply. She didn't understand why immigration refused her. We started by analyzing her refusal letter. Immigration cited two concerns. First, course progression. She'd completed a Bachelor of Business and worked in marketing for 3 years. Now, she was applying for a Master of Information Technology. Immigration saw this as an unexplained field change with no logical connection to her background. Second, weak ties to home country. Her statement mentioned wanting to return home but provided no evidence of property ownership, ongoing business interests, or family responsibilities that would ensure her return. We examined her actual background. Turns out, her marketing role involved managing digital campaigns, SEO, and analytics tools. Work that bridged business and technology. She owned an apartment in her home country and had a registered consulting business. None of this appeared in her first application. Our approach had 3 parts. Part 1. We selected a different course, Master of Digital Marketing and Analytics. This program explicitly connected her business background to technology skills. The progression made logical sense. Part 2. We rewrote her genuine student statement to directly address the refusal reasons. We explained how her marketing experience involved technical tools, why she needed formal IT training to advance to senior digital strategy roles, and why Australian programs offered practical training her home country lacked. Part 3. We documented her ties. Property deeds showing apartment ownership, business registration documents, a letter from her current employer confirming approved leave and guaranteed position upon return. Result? Second application approved. The refusal rate for repeat applications after a first refusal typically runs around 35 to 40%. Your second attempt needs to correct the specific weaknesses immigration identified. That requires understanding what they are actually testing for. We specialize in 6 types of complex cases. Student visa refusal. We analyze refusal letters to identify immigration-specific concerns, then rebuild applications with targeted evidence addressing those exact issues. Student visa cancellations. These occur when you breach conditions, work hour violations, attendance issues, course progress failures. Cancellations trigger mandatory detention considerations and affect future visa eligibility. They require immediate legal response. Genuine student concern. Immigration questions your course logic when your background doesn't align with your study choice. Today, genuine student requirements tighten further. Immigration now expects detailed career planning, evidence of research into course content, and clear explanations for any field changes. Course progression issues. Switching from higher to lower qualifications raises immediate red flags. So does changing courses multiple times or extending your study duration without clear rationale. These patterns need professional justification with supporting documentation. Graduate visa pathways. Your student visa is one stage. We map eligibility for subclass 485 temporary graduate visas, assess whether you can include dependents, calculate your points for potential skilled migration, and plan the transition between visa types. Administrative Review Tribunal Appeals. If your visa is refused and you want to appeal, you're entering a formal legal process. The tribunal has specific procedural requirements, evidence standards, and hearing protocols. The tribunal received over 60,000 migration-related applications. Your case needs to be presented correctly the first time. Most education agents don't employ registered migration agents. When visa complications arise, they refer you externally. There are 2 problems with that model. First, information loss. Your case details, academic history, and personal circumstances have to be re-explained to a new advisor who doesn't know your background. Second, accountability gaps. The education agent isn't legally responsible for migration advice. The external migration agent doesn't control your education pathway. Nobody owns the complete picture. Our registered migration agents work directly with you from initial assessment through visa grant. They understand your full academic history because they've been involved since your first consultation. There's also regulatory protection. Registered migration agents operate under a code of conduct enforced by the Office of the Migration Agents Registration Authority. We carry professional indemnity insurance. We have legal obligations for the advice we provide. When your future depends on getting this right, that accountability matters. If your case is straightforward, recent graduate, clear academic progression, no refusal history, many agents can help you. If you're facing refusal, cancellation, or concerns about whether your pathway will satisfy joining student requirement, you need migration law expertise. Contact Education One Australia for a case assessment. We will review your situation, identify potential issues, and show you what a defensible application actually requires. What's your next step? Get your case reviewed by someone who understands both education pathways and migration law, because that's what determines whether your visa gets approved.